Good evening.
Good evening,
You are live here at Courtside with Lawman,
Carmen B.
and we are here to talk about laws and the criminal justice system and how it affects the public.
Right, we're going to focus in on criminal law, of course, because that's what we do. And we've been doing this probably 60 years between us, starting way, way back. Now, between us, like I said, we have so many years of experience of doing criminal law. So we feel that we want to bring our education and our knowledge to the public and try to enlighten, inspire, and, inform.
Yes, we are an informational and an educational show. You are invited to call in at 916-443-5288 or to ask questions or comment in the chat. We want this to be an interactive space and we want the public to participate.
And also realize that anytime that we are discussing questions or issues, that we are not creating an attorney-client relationship between myself and yourself or Carmen B and you. So um, we are not your lawyers, so to speak, when we answer. It's only advice only.
Yes. If
Okay.
you have questions where you need legal counsel, you can certainly call either of our offices to schedule for a private meeting where we can discuss those issues. But we certainly encourage you to ask your questions that you have in the chat and we will answer them.
Now, to start off with, I guess, Carm, maybe they should know our phone numbers at our offices. So I'll start. I'm 916-443-5600. 916-443-5600 for Keith Staten.
And my office number is 916-443-5288. Again, 916-443-5288.
Well, beginning the new year,
We'd
lots
like
of things have changed.
Yes, we'd like to start by saying Happy New Year. We are now in 2022
Yes.
and ready to get at it.
And we want everyone definitely to pay attention to COVID protocols. Take care of yourself and keep yourself safe as best that you can. We don't want to lose people.
Not,
So, yeah,
yeah, certainly not unnecessarily. There are ways to protect yourself, and we ask that you follow those ways, even if you're someone who believes that this illness is not a threat to you because you're super healthy. You have to think about the other people around you. You have to think about other people who may have conditions that you know nothing about, but that make them more susceptible.
correct,
As a community, we have to care about each other.
correct. So, the first subject matter of the year we chose to be new laws in 2022. So, new laws that could affect you, your family, your loved ones, things like that. Just new laws that are coming out that you should know about. I would start by saying that each year the governor signs legislation into law. All right. So, you're always going to have things changing. One of the major changes is what CDCR is doing in terms of prisoners. And what they're doing is their policy is that they're trying to shorten sentences. There was a mandate years ago that you had to get lower the population of our prisons.
Because the prisons were never meant to hold the numbers that they are holding. They were not built to hold those numbers of people. And there was severe overcrowding. And when you have overcrowding, other issues are going to arise from that. The medical care is going to be substandard. There are going to be issues amongst the people who are housed because there are too many of them housed together in a small space.
Right. And this is all as a result, I believe, of our mass incarceration period that we did go through. And now we've seen in the past several laws change that allow people to get relief, even in prison, even after sentence, such as taking out 1 year priors, taking out 3 year drug priors, um, having discretion on gun enhancements. Those things are already in place. When the proposition that we passed that actually allowed probation now to be 1 year for misdemeanors and 2 years for felonies, except for DV, serious and violent felonies, and child sex issues. So you see, the law is always changing and new things are popping up. And a lot of times people get confused about what applies to them or not. So we want to just talk a little bit in the first segment here about some of the new laws that are coming into effect that might apply generally. And then we will have to get into more that may apply to individuals who might be incarcerated or yet to be incarcerated. So, you want me to start, Carm?
Go ahead.
All right. First of all, there is a SB 389. It allows restaurants and other establishments with a liquor license permitted to sell to-go wine and cocktails. So as a result of probably the pandemic and individuals switching to ordering up food and to go and things like that, the governor has now signed into law stating that as long as you've got a liquor license and you're selling the liquor under that license, that now you can sell wine and cocktails to go. Now, the thing about that is, if that's what you do, that's what you do, okay? But it's only going to December of 2026, and the hidden issue there is that still you should drink responsibly. Just because you can get your alcohol to go doesn't mean
you should be drinking it in the car, because
exactly.
What we don't want to see is people ending up with more DUIs because they picked up their food,
right.
They have their alcoholic beverage, and they think, well, I can just drink this while I'm driving because
right.
they served it to me. So you're still not allowed to drink it while you're driving.
Exactly. And along that same vein, there's things going on now whereby automobiles may be manufactured in order to detect whether a person may be under the influence through infrared cameras and other devices, like heat devices where you would touch it and it can measure how much alcohol is in your blood before the car will actually start and move. Manufacturers are going to start putting that on their vehicles, and it would be mandated. So it's a good thing in terms of it does prevent individuals from driving.
When is that? That's sometime in the future.
Oh, yes.
That's nothing that's happening now.
They're doing prototype tests and things like that right now. But when it does come, it's probably going to be a mandate for all automakers to keep it on there, because they do a lot of things right now with computers, being able to mark your speed, your travel, everything already electronically in your car. So now it's just going to be able to detect individuals who may be drinking a little bit too much. Now, one of the second things you want to talk about, Carmen, is spousal rape and how it's going to be treated differently.
Yep, I will allow you to go ahead and discuss that as well.
Okay, AB 1171 alters the penal code so that spousal rape is no longer treated differently than rape.
How was it treated differently before, lawman?
Well, it used to be, and I would say probably about 15, 20 years ago, maybe a little bit more, further than that. But spousal rape was not a crime at all, meaning you can rape your spouse and it would not be a crime. Now, we criminalized it, but the penalties were far less than what's regular rape. Exactly. And so really the act of rape, which is intercourse with a penis, unlawfully, which means without consent, it's the same thing whether you're a spouse or a stranger. Basically, it's the same act. And so this is very similar to how they treated meth and cocaine, where cocaine offenses, rock cocaine, had a much higher penalty and punishment than regular cocaine use.
Well, there was a different reason for that, though.
Oh, I understand. But it's similar in the way that we can draw statutes and bring them out here and they could be unfair. And then we have to do something to try to make them fairer. Okay. So just know that that's coming up. Now, also, AB 1475, mugshots being released by the police. AB 1475 will limit the circumstances in which law enforcement is allowed to release the mugshot of a person on social media in order to better protect the people and their rights who've been arrested but not yet prosecuted. Now that's important because
not yet prosecuted or not yet convicted.
Well, not yet convicted, but yet prosecuted. But even still, if you're not yet prosecuted, because you can be arrested and they don't file charges for a while.
Mm-hmm.
But yet you've got this mugshot that's being thrown around out there and before charges are even filed. So why is that? And what principles is that based on, Carm? What do you think?
The change in the law?
Oh yeah, about police not being allowed to throw your mugshot out there.
I'm certain that there was probably someone of a person of power or the child of a person of power who was arrested for a crime and perhaps never charged, but their mugshot was circulated.
Because you see it now, people put out articles in local newspapers and stuff about crime in the neighborhood, and they mention names and things of people who are arrested.
Well, that happens. That happens all the time.
Yeah.
That someone's arrested for something they haven't been convicted, but their mugshot is put out there for the public to see. It's shown on the news.
Yep.
But this doesn't impact, I think, whether or not if some other organization gets a hold of it. But it's specifically related to
law enforcement can't release it. Exactly. Now, the next one, extremely important. And this one is something that we harp on all the time. You got to understand the new rules real fast about voting, okay? You can vote if you have misdemeanors, felonies, if in fact you might be in county jail. The times that you can't vote would be actively on parole, actively in prison. Outside of that, you can vote. If you've got a past record, you can vote. In fact, if you've got a felony, you can serve on a jury now. But the voting is most important because people who have been disenfranchised for years or who thought, I have a criminal conviction, therefore I can't vote, you were probably wrong. And this is a message that has to go out throughout our communities.
To let people know that they can vote. Again, you can't vote if you're actively on parole. But if your parole has ended, you can vote. You can't vote if you are actually in state prison. And I think that applies. We need to be clear on this. So, because there's a different types of state prison now.
Sure.
So there is county jail state prison. And then there is actual state prison where you're transported to a traditional state prison facility. Right. If you are in county jail, but serving a county jail state prison sentence, that still qualifies as a state prison sentence and you would not be allowed to vote. But if you are in county jail serving just a county jail sentence, a regular county jail sentence where you're on probation,
right,
you are allowed to vote.
Exactly. Now, what the law changing will do is now, and what we've been doing, and you see this across the country, starting in 2022, the state's going to require election officials to mail ballots to all registered voters.
And I believe in Sacramento County, we've seen that already happen the last, certainly the last election.
Right.
I believe
through COVID, I believe they've been trying to do that.
Was mailed out a ballot. Now, even though the ballot is mailed, if you still want to go and vote in person, that you certainly can still do that. But the mail-in ballot allows for a little bit more ease of voting for someone that maybe works hours that make it difficult for them to get to the voting centers.
The elderly, even youth who don't have cars or transportation.
Yes.
So it is vital, and it is so important that you ask to register to vote. It is one application that you send in.
You can't complain about what the politicians are doing if you're not participating and selecting who you want to be in office. And it doesn't end with selecting them.
Right.
Your voice can be heard by contacting your local representatives, contacting their offices, requesting a meeting with them, letting them know where you stand on certain issues, letting them know what things are important to you.
So, and that's a theme that I think you're going to hear from us throughout, because every time an election comes up, it is valuable. You may think if it's not the president or something, a mayor or something, that is not important. But what you got to understand is we vote for city council. We vote for people who sit on boards, who run school districts and things like that.
We vote for district attorneys.
Yes. We vote for judges even. So, and of course, assemblymen and senators and all those too. We vote for so many propositions that talk about spending our money and where we spend it. So, as a citizen of the United States, of California, of Sacramento County, we are begging everyone to definitely become a more aware voter in 2022. If you had a resolution to make, I would say make a resolution that I vote in 2022 and then go register and be ready to do it. Now, anything more on that part, Carm? Because
I don't think so. And again, you'll hear us again mention the
we'll preach
importance
this.
of voting.
Absolutely. Now, I want to hit one more and then we'll go into something else. But here's one that's really important. SB 2 passed. Now, we've been trying to do a lot of police reform legislation for quite a while now. The Stefan Clark bill, they called it, AB, I think 382, I believe it is. But that bill kind of changed the way we looked at unlawful force from police officers. It kind of made it to use lethal force as a necessary thing instead of just being the officer allowed to use lethal force first. What they want to do is ratchet down that lethal force being only necessary to prevent the death of someone or the officer or bodily injury, obviously. But you couldn't sue the officers for their misconduct if that's what you felt that they did. Now, we have SB 2, which is a police reform bill that was signed into law in 2021. And that law allows the state law enforcement accrediting body to decertify officers for serious misconduct. The reason that's important is because officers could commit misconduct and the record of that misconduct will not follow them to the next jurisdiction. And now
if they decided that they were going to leave one law enforcement position, let's say they were with Sacramento Police Department and they decided that they were going to go down to the LA Police Department, that any misconduct allegations would not follow them.
Right. And the problem is that you get officers who are bad and then they move to another jurisdiction and nobody stops them. There's no licensing agency like it would be for lawyers, like it would be for any other professionals, doctors and things like that. If you do something wrong,
nurses.
Yes, there's a licensing agency, hell, car dealers, things like that, car salesmen. If you do something wrong, then they can take your license. Therefore, you will not work in another jurisdiction. And that's what SB 2 is intended on doing, allowing us to identify officers who have committed misconduct in one area and allowing them to be kicked out of the profession, basically, when they commit certain kinds of crimes and things against people. So those are some of the bigger
and
laws.
Not even necessarily always arising to the level of a crime. It may be just substantial misconduct.
Yeah.
And ethical violations, because sometimes those don't arise to the level of crime, but it is still a huge problem.
So those are just some of the new laws that affect individuals that may have a criminal edge to them, or at least are interesting and notable, so that we should inform you of. If you rewatch the show, get the numbers and things like that, that'd be fantastic. Now, there is one law, and that was SB 81, regarding sentencing and dismissals of enhancements.
Well, lawman, doesn't that mean enhancements are all gone? They're gone. No enhancements against anybody. No additional time for any act that could be an enhancement. Isn't that what that means, lawman?
No. And first of all, Carmen, explain, what is an enhancement?
An enhancement is a specific allegation that certain conduct occurred, and as a result of that, there is an additional punishment that can be imposed in addition to the substantive crime.
Now lay it out. Let me ask,
So, for example,
robbery.
If I were accused of a robbery, and in that robbery, I had walked into the Shell gas station and I had a gun in my waistband, And I just opened my coat and said, "You see this, you know what this is, give me all the money." That qualifies as a use under criminal law of that weapon, even though I never pulled the weapon out. I never pointed it at anyone. They didn't even actually see the full weapon. They only saw the part that was sticking out. But if they believe that to be a real gun, that enhancement can apply.
Now, I would say there's several other enhancements that we should probably mention. For example, there are ones for the amount of dope in a dope sales case. There are ones for the amount of money loss in money fraud cases.
There are an enhancement for great bodily injury, actually causing great bodily injury, or also known as serious bodily injury. That one adds an additional 3 years. The gun enhancements can, depending on the circumstances, use can add 10 years. A use which results in a discharge, even if no one is hit, can add 20 years. A use where someone is where it is discharged and someone is actually hit can add 25 to life.
And there are other enhancements, such as gang enhancements,
Yes.
That they can attach, where they are alleging that the reason for the crime was to further a criminal street gang. There are enhancements for having prior strike offenses. Now, sometimes we know we've fought the strike law for quite a while. The strike law used to punish individuals with 25 to life when the third strike was not a serious and violent a crime.
It could be anything. And so there were people who had, they had serious or violent convictions in their past. And then they did something so simple as stole a pizza, stole a wallet, stole a bike, and they were getting sentenced to 25 to life. And then I believe it was in 2014 that the law changed. I believe it
where the third strike
was then required to also be a serious or a violent crime.
Correct.
So that we could prevent people who were committing petty crimes from being sentenced so harshly.
Now, what it did was what we would call it mitigated that 25 years. What it meant was, I don't care how many strikes you had in the past, they can use one of them. And what using one of them did was it mandated prison, number one, but doubling the term that you can get in the present case. So present case was a regular felony. It's 16, 2 years, 3 years minimum. However, if you had a strike that is filed that is not dismissed pursuant to Romero Williams striking of the strike, and those are two cases that are used to strike strikes because they are too old.
And strikes. We say strikes. It actually, the word strike there means to dismiss the strike prior, to not use the strike prior against the person in that particular case.
And when that happens, then the individual could get probation or the 16, 2, or 3. But if you haven't struck that strike, okay.
Now you have to remember that not all of our audience understands 16, 2, or 3. Sometimes we're talking in the jargon, and we have to realize when he says 16, 2, or 3, he's talking about a general felony where the punishment is 16 months state prison, 2 years state prison, or 3 years state prison, or probation with some amount of county jail time up to 1 year.
Correct. So if in fact you fall under the 3 strikes law and they file a strike against you, SB 30, the law I'm going to talk about, would not apply. Now, the law is within Penal Code Section 1385. And what it is designed to do, and if you want to start, Carm, but
I'm going to ask you one thing just because I'm not sure if I misunderstood you. Oh. Are you saying that 1385, that cannot be used to dismiss a strike enhancement? Because I believe that it can.
Well, let's explain. 1385 is actually a provision that whereby the court is allowed to strike things, enhancement charges, under what's called will be the interest of justice. Okay, so if there's a righteous reason to get rid of something, a court can exercise its power under 1385.
Doesn't mean that the court will, just means that the court
Can. It gives them discretion to do so. And what it does is, and now in the new year, what you're going to see is the courts during a sentencing and where there are enhancements charged, a court may have discretion to actually dismiss all enhancements. There are some rules that come along with it, like serious, not serious and violent, not sex crimes. You see, things like that. But if you have some enhancements, the court does now have discretion to get rid of them. Now, I think in talking with some prosecutors and talking with defense lawyers, there's a slippery slope here. This is very similar to the Humphrey bail issue, where everyone thought, well, hey, if they got to consider how much money I make and I don't make much money, they got to lower my bail down. But if there's any way to tie the crime, to any kind of violence, any kind of danger to the public, and I don't mean everybody in the public.
Let's just be clear. It's not just violence, because you can be found to be a danger to the public if you are selling drugs, because what you're doing is causing harm to the community. So it's not limited to just crimes that are violent crimes.
However, if they can tie in that, and she's right, but it may be other stuff, but if they can show that you're a danger to the public in any way, then they do not have to exercise their discretion. And in fact, what we saw with the Humphrey cases, the bail, money bail, and things like that, what we saw were courts were finding that the individual may be a danger to the public, and what they were doing was then no bailing people, actually raising it to no bail.
Not what they were doing, what they are doing. What they are doing.
Well, lawyers should be wise enough now to stop doing that.
Well, to very carefully consider making a bail motion. Because your client's bail may be set at $200,000.
Right.
And of course, that is extremely high. The average person doesn't have $200,000 cash sitting around, nor do they have the 10% of that, which would be $20,000 cash sitting around to get out. But if you make that bail motion and the court increases that bail by finding that they are a danger to public safety, it's not really an increase in bail. It is a setting of the bail at no bail, meaning no amount of money can be paid to get this person out of custody while their case is pending.
Right.
So their family could be the person who hit the lottery on, I think the other night there was a almost $600 million lottery, and it was sold here in Sacramento, California. I think in South Sacramento. If Lawman got that, he better let me know. But if their family was the family who had won that money, and I think it was split between here and another state, so $300 million, they would not be able to get the person who has a no bail out of custody. So it is better to leave it set at $200,000 than to have it go to no bail.
Bottom line, enhancements may be considered to be stricken by the court, and the court needs a reason to do it in the interest of justice. Why it would be judicial, why it would be beneficial to strike those strikes, strike those enhancements. And one just example would be this. If the enhancements added up to way more than what you get for the crime itself, a judge can exercise their discretion to do so.
And I actually want to read some of the factors and that the court can consider. If the application of the enhancement would result in a discriminatory racial impact, as described in paragraph 4 of subdivision A of Penal Code section 745. If multiple enhancements are alleged in a single case, all the enhancements beyond the single enhancement shall be dismissed. If the application of the enhancement, meaning the sentencing to that enhancement, could result in a sentence of over 20 years, in that instance, the enhancement shall be dismissed. if the current offense is connected to mental illness, if the current offense is connected to prior victimization or childhood trauma, if the current offense is not a violent felony, if the defendant was a juvenile when they committed the prior offense or the current offense, if the enhancement is based on a prior conviction that is more than 5 years old, if a firearm was used but it was inoperable or unloaded. And then it specifically states that those factors, those circumstances are not exclusive. So the attorneys can be creative in presenting other mitigating factors.
Right.
Now, what we're talking about, though, is people have been reading that and saying, oh, it says shall be dismissed. Therefore, enhancements are going to be gone. Judges aren't going to be able to apply them. There's not going to be any additional time sentence.
Is that
what
true?
you need to understand is that in exercise, I'm going to read exactly from the law. In exercising its discretion under this subdivision, the court shall consider and afford great weight to evidence offered by the defendant to prove any of those mitigating circumstances. But unless the court finds that dismissing the enhancement would endanger public safety. Endanger public safety means there is a likelihood that the dismissal of the enhancement would result in physical injury or other serious danger to others. So please, people, you need to understand enhancements are not gone. The court can still impose an enhancement if it finds someone to be a danger to public safety.
So we want to thank you for joining us on this initial show of the new year 2020. We want to invite you back and bring your friends along. Give us subject matters that we'll talk about. But next time we're going to go more into some more new laws and things.
And we
as
do
part
need
two.
To pay homage today.
Yes. Of course, one of my heroes, an individual who I love every movie that he was in, pretty much, Sidney Poitier, passed away. We've been losing a lot of people lately. We're seeing it all around in the sports world, the entertainment world, in everybody's home. We're losing a lot of people, but Sidney was definitely a groundbreaker. And if you have not seen his movies from the 60s, Sidney Poitier, please go out and see a couple of these movies, because this was a man who was playing a very strong black man in the 60s when that was not the norm.
Not at all.
At all. And so
But he
Harry
also
Belafonte,
he played strong men who were very poised,
yes,
who were extremely intelligent.
Black Doctor.
Yes.
Things like that.
And who dressed well.
Oh, yeah. No, he showed a lot of class. Him and Harry.
And we need more of that. We need that.
Harry Belafonte. They both, exuberated that. And one good thing about them both is this. Look, when the cause was called to help in the civil rights movement and things like that, these were people behind the scenes who were doing what they can. Just like you got to look up what Mahalia Jackson, the greatest gospel singer around, was doing. There were a lot of people who were entertainers and performers at that time who gave a lot of their time and effort. Dick Gregory. I mean, you can go through it all. If you were in that period of time, you were behind the scenes or up front fighting in the civil rights movement. So he's a very important man. Kids should always look him up in his movies. So, Carm, we're at the end of the show. So we want to thank you again. Come back to us again, please.
We'll see you courtside next Friday at 6 p.m.
with
Lawman
and Carmen B.
Thank you.
Thank you.